Good evening, everybody. A very warm welcome to all of you here and to those who are attending virtually. Since I'm standing here, I'd like to mention, for those who are newcomers and do not know us yet, that the Center provides unbeatable panels for you who focus on the subject matter in depth. As a founder and chairman of the Center, this is my charitable job for you and for the dissemination of knowledge and for the benefit of the industry. But my day-to-day job is dispute resolution. Today, we have an unbeatable panel as well, which is led by formidable Sir Bernard Eder, who is going to introduce the panelists. I do not need to make an introduction for him because he's well known to you all and internationally for his past successes and currently as an arbitrator. So I think we are set for a very enlightening event and panel debate. And it's all over to you, Bernard.
Thank you all for coming. I know there are people online. I'm only looking that one of the speakers is Richard Watts, and I hope he's there. Right, there's Richard. Good. Well, I start, first of all, with a thank you. I then want to make an announcement, and then I have a confession. Thank you is to 36 Stone and to the IDRC. This is sponsored by 36 Stone, and I see drinks and other things, I think food afterwards. So a big thank you to 36 Stone. The announcement is that Julia Dias has been made a High Court judge. And those who didn't know it, I'm telling them now, that is a great appointment. She is a great shipping lawyer, and it is great news that she is joining the bench, I think, on Monday morning. The confession is that I know nothing at all about this that we're talking about. It's digitalisation of electronic documents. I did draft, I think it was, I'm going to say 40 years ago, one of the first set of electronic documents, believe it or not, must have been 30 years ago. So I did know something about this, but I know nothing at all now. But we're privileged to have not only the panelists, who I'll introduce in a moment, but Lord Thomas, who chaired the committee, I think, in the House of Lords that considered the Electronic Trades Documents Bill. That is the main focus of the discussion this evening. Very briefly, to introduce the people, there will be, first of all speaking, there will be Richard Watts, who has spent his whole life in the shipping industry. He concentrates mainly on carriage of physical commodities, and he is joining us, I think I may have said or not, is from Geneva, and he will be speaking first. After Richard, I'm going to ask Francis Strickland, otherwise known as Franny, I'm told, to speak, and he will introduce, in particular, the bill. Then I'm going to ask Professor Charles de Battista to speak, and he will speak on a number of particular issues with regard to the bill. And finally, Matthew Wilmshurst, from Holman, Fenwick & Willan, a partner there working principally in the shipping sector, concentrating on logistics, I think, and international supply chain. So perhaps like many of people here today, I'm on a steep learning curve, and I look forward to listening to what everyone's going to say. So thank you for coming. I don't think there's anything other formalities. I've told the speakers that they each have not more than 10 minutes when the floor will open up and they will all disappear, I think. Right, so welcome all and welcome Richard. Richard, I hope you can hear us, me.
I can.
Right, so kick off with you now. Thank you.
Well, thank you very much, and delighted to be with you all today. I'm sorry that I can't be with you in person, and certainly that I can't share with you the drinks that you're going to be having afterwards. Thank you very much to the organisers for organising this event, and I'm also hoping that I'm going to learn quite a lot about the various aspects of the Bill of Lading. It's a complex subject, and I think there's a lot for a lot of us to learn. I've spent more than 20 years working within commodity trading, and so really been focused on the physical side, the operational side of the business, and often dealing with Asia and Africa, and dealing with nearly all different types of commodities. So I've got a little presentation here that I'm going to share on my screen. I'm going to ask if I believe that there's a presentation here. And so I'd like to just share my screen. And so really, we're talking about digitalization here. We're talking about, well, I'm talking about the complex interplay of points of view with respect to the different actors in digitalized bills of lading. Well, basically what I'm talking about is who wants what? What are the different positions of the different actors which are involved in this discussion? So my own personal position, where I stand, I'm not a lawyer. I'm not looking at the legal aspects of the bill itself. I'm not a IT professional. I'm not looking at the different technologies which are available. I am a user. I'm looking very much at the day-to-day aspects of this business. How do we actually use it in real life? I'm also coming at this from a position of somebody who is vastly fed up with the fact that we spend all our time running around after paper documents. And I think that's something we really, really, really need to change, because we do have to admit that this is the 21st century. Now, we seem to be speaking about electronic bills of lading for an awful long time, and it's felt for all this time that the industry's position hasn't really moved that far. It's been a lot of attempts at moving forward, but we seem to still be discussing the same subjects. Now, I'm hoping that with new laws coming into play, we're going to have a lot more progress being made and not just find ourselves being stuck in the mud again. So really, it's a question of looking at the points of view. And as with any situation, any subject, there are a lot of different points of view. And it's just important to understand those different ones, because certainly when we're talking about bills of lading, there are so many different points of view. There are so many different interests of the different actors who are involved. And it's important to understand them, because otherwise there's no way that we can succeed and have something that actually works for everyone. So I'd like to go through some of these different points of view, the different people who are involved, and really start talking about the commodity trader. So as far as the commodity trader is concerned, they really want to make everyone happy. They would like their supplier to be happy. They'd like their receiver to be happy. They'd also like their banks to be happy. And so often it kind of seems like they're in a bit of a difficult situation. But really, there's a lot of opportunities available. There's a lot of different aspects of electronic bills of lading which can make the trader's life much, much, much easier. They want to get paid quickly. They want to pay less financing costs. And so certainly electronic documents allow for that. They would like the bill of lading to be negotiable. They want their business to run smoothly. They want to be more efficient. And also they want any system to integrate into existing systems. We have way too many different systems within trading companies that are all vying for attention, and we need them to work seamlessly together, and that is a real challenge. We also talk about the bill of lading in terms of an electronic document, but when we're talking about goods like grain, we have to realize that there are a lot of different documents which we transfer at the same time. So then the question is a system that can use electronic bills of lading, is that able to handle other documents at the same time or not? It has to be something that's useful to the users on a day-to-day basis. Now, within commodity trading, certainly traders, we don't like change. It's interesting because we look at it as a business where we're trying to adapt to markets, but we don't like things changing. We're very scared of the concept of, is our data going to be are the data that we store going to be secure? Who's going to have access to this data? It's interesting because all of us are quite happy to use electronic banking on our mobile phones. But we're very concerned about the data about our trades and what goods we have and the quantities and the different cargoes loaded on different vessels. We're also, to a certain extent, a little bit concerned about our banks having a bit more information about our business than we'd like them to have. This is interesting because it doesn't really make that much sense, because actually the banks have a lot of information, and I would say it's often better for them to be getting that information from the trader than elsewhere. So the data there is something that I think is quite useful. If we're looking at from a charterer's point of view, so traders are often in the charterer's shoes, and they will then have to negotiate in the charter party, make sure that there are proper clauses that allow them to use electronic bills of lading. And so certainly if they have long-term time charters, then this is something that needs to be thought about in advance. That being said, we also have opportunities regarding the letters of indemnity. I mean, at the moment, a charterer can discharge the cargo when they want against an LOI, but that creates a huge number of risks, a huge number of liabilities, and we can remove those by having electronic bills of lading. And so it can actually make everyone's life an awful lot easier. If we move on and we start looking at it from the carrier's point of view, well, here we can look at a reduction in fraud. If it's done properly, then we can massively reduce the potential for fraud, the risk of false bills of lading. We imagine a system where the banks and the shippers and the receivers and the traders are all expecting electronic documents. If someone turns up with a paper bill of lading, they're not going to get very far. And so if the system is done well, then you're only going to be able to have one set of documents in circulation. So as far as the carrier is concerned, it should make their life an awful lot easier. They also don't have to be discharging against LOIs. We can just authorize the discharge directly through the electronic bill of lading system, and we can end up having the cargo released that way. So that should make life also a lot easier. Also, there are reporting requirements. So, I mean, the issues today with the Russian oil cap, how is that going to be working? And if ship owners are obliged to make reporting about the cargo they're carrying, then an electronic bill of lading system could make that an awful lot easier. However, from the carrier's point of view, how many different systems are they expected to learn how to use? Are there going to be many different systems that they are using at any one time? But if you move on, if you look at it from the shipper's point of view, they basically need to have a document that's issued upon the completion of loading. So they would need to draft the bill of lading in the system or confirm the contents. They would also need to have the bill of lading released to them as the receipt for the goods that have been loaded. They would also need to be able to transfer the ownership and get paid for them. So they would see this as a potential streamlining of the process, reducing the paperwork and reducing the risk of errors. But then they also have risks of security, and legal situation in different countries can be different, but it can make their life much, much easier. From the receiver's point of view, also very similar. They basically want to be able to receive the goods, and so we won't have to deal with letters of indemnity again anymore, as I said. Also, they want to be able to make a claim in case there is damage to the goods, and also they might need to make local declarations to authorities such as the customs. And so this needs to keep in mind, can the customs actually receive an electronic document, or do we need a way of materializing that document in order for it to work for the customs? If we look at it from the bank's point of view, this is possibly the most complex and possibly the most problematic. I think that they probably have the most to gain out of everyone, to be honest, but I think also the way the bank systems work at the moment does complicate matters quite significantly. And so depends really how the deal that is being talked about, how the transaction, whether it's being financed, what type of payment method is being used. But also the bills of lading, again, need to be negotiable. We need to be able to endorse them. We also need to make sure that the BL provides sufficient collateral. It also has to be useful from an accounting point of view for the bank, because there are a lot of regulations in different countries of how they can account for these collateral under their lending requirements. And we also need to be able to use the goods to control, they need to be able to control the goods if there's a lack of payment to them. So from the bank's point of view, this is actually quite a complicated subject, and one that they really need to get their heads around. We also have the insurance point of view. So when the vessel arrives at the discharging port, if there is damage to the goods, if there's claim, then we need to be able to make that claim using the bill of lading as that evidence of the contract. Now, one of the most interesting areas for me is the data. There are so many opportunities in data. First of all, we start off with a bill of lading is attached to a vessel. That vessel is attached to an IMO number. With that IMO number, we can identify the owner of the vessel. We can identify the beneficial owner, the manager, all these different parties. So from a purely compliance point of view, it is a leap forward. And so this can create so many opportunities. Today, we're really not using a lot of the data that we have. We're spending a lot of time entering data twice into the same system or into multiple systems. And also the opportunities for data sharing should be interesting. Again, I don't think we should be scared of this because we should realize that a lot of the data is out there. But if we provide methods for efficient sharing of data, then life will get an awful lot easier for everyone involved. So there are a number of different angles. There are so many different points we can go into, but I think really what we're going to be talking about is collaboration. How do we work together going forward? All the different commodities that we deal with, they're not that different actually. And so there are an awful lot of similarities. And how do we get the different areas of the business to work together? How do we get the different actors to work together? How do we bring together the banks, the shippers, the receivers, the traders, the insurers, the ship owners, all these different parties? So that's all that I have time for now. I've been given 10 minutes and I think I have quite diligently stuck to that. And so I'm hoping that we're going to make some progress in the world of electronic bills of lading and really make a start now. And with this change in the law that we're seeing at the moment, that might be happening. So that brings me to the end, and I hope that I've been within the time that I was allotted.
Great, thank you. Thank you very much, Richard. And now I'm going to ask Francis, I think Francis Strickland, to speak. And he's going to speak in particular about the various products, I think, currently available in the market. Is that right?
Yeah, I'm going to do three things. I'm going to speak pretty briefly. I'm going to talk first just to go back and bore you about the basics of bills of lading and how they work. Secondly, identify why there are issues with paper bills of lading and why the move to electronic bills of lading could be particularly useful. And thirdly, I'm going to talk very, very briefly about the legislation at a high level and about some of the current players in the market or that could move into this market. Let's see if this moves yet. When a ship, well, let's take an example. Let's say Lord Thomas decides that he wants to ship 1 million teddy bears to Mo. And let's say Lord Thomas is in Southampton and Mo's in Sao Paulo. He's going to load his teddy bears onto a ship and he's going to get given 3 pieces of paper, hopefully identical, these bills of lading. These bills of lading are going to act as a receipt to show that he's loaded them on board. And they're also going to represent a document of title. So that document of title could be just negotiable, or it could be negotiable and transferable. And if it's also transferable, it'll enable Lord Thomas, while these teddy bears are in transit working their way to Sao Paulo, to sell the teddy bears while they're on board the vessel to a third party. And in so doing, transferring constructive possession in these teddy bears and the rights to sue the carrier to whoever he decides to sell them to, pursuant to Section 2.1 of COGSA 1992. The buyer, though, Mo, needs those pieces of paper. He needs the bills of lading in Sao Paulo to be able to go to the carrier and demand delivery. Or, as Richard rightly identified, it's possible to obtain delivery against an LOI, but there are risks in doing that. The problem with or one of the problems with the current system is that bills of lading are very slow to transport, relatively speaking, at least in relation to things sent over the internet. Couriering, when you send bills of lading from a shipper to a buyer or a consignee, it takes days to do that. Sometimes that is too slow for various reasons. So that it's not infrequently that you'll find a scenario where the goods will actually arrive in port before the bills of lading do, particularly if there had been a string sale at some point, a late-ish point during the period of transport. It can be, the process of transferring bills of lading can be even slower when you involve banks. Richard touched on this himself. And you frequently get situations where traders let's say you've got an oil and gas trader, they want to buy a cargo, rather than pay for it themselves, they'll use trade finance and pledge the cargo to a bank. The bills of lading may be issued with the bank as consignee, but banks tend to take quite a while to process bills of lading. So let's say it takes 2 or 3 days for the bills of lading to reach the bank. It'll take the bank another 5 days to determine whether or not the bills of lading are compliant. So there are another example where bills of lading take, paper bills of lading, that is, take quite a lot of time. Paper bills of lading, not to get too eco-friendly, but I think it's important, also waste an extraordinary amount of paper. I did a quick check before we came here, and there are 60,000 bills of lading issued in the US presented to the US customs authorities every single day. So if you extrapolate that across the globe and then times it by 365, that's quite a lot of pieces of paper. So there is an obvious environmental incentive for us to shift away from paper bills and move to e-bills. The electronic trade documents bill that we have in front of us here, I don't know whether you guys got it on your seats as well, envisages certain documents being the functional equivalent of their paper counterparts. But in relation to bills of lading, one must be able to transfer exclusive control from one party to another and distinguish between what are the originals and what are the copies. That's, I think, section 2. At the moment, we have a number of platforms or parties ready to start trying to sell you their services, so you can use e-bills on their platform. And I like to think of them at the moment a little bit like horses in a starting block. You've got a load of thoroughbred horses all offering you their great wares, but there aren't many states yet that have legislated to make e-bills lawful tender. I think Singapore has, I think Bahrain may have done as well, and maybe one other Middle East state. Lord Thomas is nodding at me, that's good. Maybe 1 or 2 other states as well. But there aren't many. I don't want to underplay the significance of Singapore, but the UK is obviously a very significant player in the maritime market. Huge volumes of international trade are subject to English applicable law. So as soon as this draft electronic trade documents bill is no longer draft, but is passed through Parliament, it will have a big effect on the market, and those horses that are currently in the starting block will be able to start running the race. It'll be interesting to see how that works. There are a number of competitors. 3 of the main ones are Cargo X, Waves, ESS Docs. We were talking about another one earlier. What was it? Trade Lens as well. One of the things that I think is particularly interesting is that a lot of them, but not all, are building their platforms on blockchain. Blockchain is good insofar as you can establish a good audit trail. So you can say X has happened, Y has happened, Z has happened. It's good for reducing fraud, but it's not foolproof. But there are disadvantages which people don't talk about very often. Whenever you make a contract on the blockchain, you pay something called gas fees, which is to physically enable the thing to happen. In my view, it's not necessary in order to fulfill the likely statutory criteria that parties build their platforms on blockchain. So it may be that we end up in a scenario where those blockchain entities end up being undercut by companies that don't use the blockchain because it's cheaper and you don't need to do it for security reasons. You just don't need it. But we'll see. Ultimately, I think it'll be interesting to see when the bill is passed and all our horses get set off, whether we do end up with a predominantly blockchain structure or a non-predominantly blockchain structure. There are pros and cons of both, but I look forward to hearing my associates on the learned panel opining on what they think is likely to happen. Thanks very much.
Thank you very much indeed. Good evening. Thank you very much for coming this evening, despite strikes, etc. Can everybody hear me? Good, excellent. I'm going to start with a personal disclaimer, and then I'm going to ask 4 questions, to which I shall present tentative answers. My personal disclaimer is that back in the 1980s, when I was working on the first edition of my book on bills of lading, I asked a very senior professor working at the university where I was then an academic, what shall I call this book? I was in short trousers then, so I had no idea what I should do with this first sort of window display of my wares. And he said, well, don't call it bills of lading, because bills of lading won't be around by the time you're my age. I was of an age then when I listened to my elders, and I didn't call it bills of lading. I called it something catchy like the sale of goods carried by sea. Years passed by. That book is now written by myself and my learned friend, Francis. And I've now grown old enough to understand that I should listen to my youngers. One of the first things Francis said was, this catchy title, can we change it? So we now called it Bills of Lading in Commodity Trades. I am not a Luddite. I have nothing against electronic bills of lading. They were there back in the 1980s, 1990s, at around the same time as COGSA 92 was being drafted by the Law Commission. And in fact, they were anticipated and provided for in the Act. They were there, they are there, they will be there. And Richard has taken us through a number of the advantages from various market perspectives of electrifying bills of lading, or in the word of the age, digitalising them, which always sounds rather more painful than electrifying bills of lading. The old-fashioned problems with digitalising bills of lading, like one Richard mentioned, what do you do with the other documents? What do you do with the SGS certificate? What do you do with the export license, etc., and everything else which travels with the what we used to call a manila folder of documents being presented? All of those problems have disappeared. I was just in chambers a moment ago before I came here, and I needed to submit an application for something, and I had to upload a number of documents which were in conjunction with that. And I came away thinking, oh, that's the way you can actually marry up an SGS certificate or an export license with a bill of lading. So things have really moved on in 30 years. And the technical problems which might have been there 30 years ago are no longer there. So my personal disclaimer is, please do not misinterpret what I'm about to say as being skeptical about the technology or about the very concept. I am not a paper zealot. I too want trade to be made as quick and as cost efficient as possible. But I now come to my 4 questions. The 4 questions are these. What might have happened back in 1992? Second, what did happen in the intervening 30 years since 1992? Third, what has happened in the electronic transport document bill? And fourth, what is likely to happen given the way in which the electronic transport document bill has been drafted? First, what might have happened back in 1992? There were 2 little subsections in COGSA 92, which gave the Secretary of State the power at the stroke of a pen to apply COGSA 92 to electronic bills of lading. They weren't called electronic bills of lading at the time. They were called something much, much longer and much, much more boring. Electronic telecommunication of blah, blah, blah. It was a very long phrase, but they were talking about electronic bills of lading. And back in 1992, the Secretary of State was given the power to simply, literally apply, simply transplant COGSA 92 to electronic platforms. That did not happen. What happened instead? Despite the fact that that did not happen, the market proceeded along its merry way. And Francis has just mentioned a number of platforms or products which the market developed, some proprietary, some not proprietary, some with a central third-party register, some not with a central third-party register, but with a carrier at the center of the hub. So a number of platforms were developed, and they were all underpinned. There was this sort of concern in the city about where's the law under this? Where is the legal underpinning? To which there was an answer. There was nothing in COGSA 92 actually saying what a paper document was. There was nothing in COGSA 92 actually saying that it only applied to paper documents. Yes, there was a plausible argument that because there was this power to extend by regulation, then that must mean that it didn't apply to electronic bills of lading, sed quaere, as we used to say in the 20th century, but not actually decided by the courts. So what actually happened was that the market went on its way. There was this concern in the city about where's the law. The market responded by saying, here's the law. And you had rule books, you had contracts between participants to the different platforms. And the common theme between those between those contracts and rule books was that they tried by contract to mimic the basic sections of COGSA 92, that is to say, Section 2, which transferred rights, and Section 3, which transferred liability. So you had exactly those two prongs being translated into contracts between the parties participating in the various platforms. So the law didn't move on, the market moved on, and then 2021 came along when the Law Commission put out the Electronic Trade Documents Bill, which has a laudable objective. The laudable objective is one which Francis has just mentioned, the principle of functional equivalence, which you will find in the bill at Section 3, subsection 2, a very, very concise, very simple section which says an electronic trade document has the same effect as an equivalent paper trade document. Bingo. Insofar as you needed a legal statutory section saying, don't worry about this document not being on paper, but being digital, it has the same effect. It then repeated itself by saying exactly the same thing, if you look at it, at sections 3.2 and 3.3 of the bill, query as to what those two subsections add to section 3.2. To my mind, it could have just stopped at section 3.2. But more importantly, that's all the Act needed to say. Because if you had an Act simply saying, electronic documents are just as good as paper documents, that's it. You have your statutory underpinning, you have your statutory authority for something which, incidentally, the market appears to have assumed throughout. Why do I say that? In the 30 years between the 1992 Act and today, there has only been one case which has troubled the High Court about the electrifying of transport documents, and that's the MSC and Glencore case, which wasn't actually about an electronic bill of lading, but about the theft of a PIN number, of a PIN number, and misappropriation of 3 valuable containers. Because of that, flip that over, if there were products out there in the market which were clearly working so well that there were no misdelivery cases arising out of the medium being used for the transport document, that must tell us something about the Act sub silentio. The Act was either sub silentio, in other words, it was in no one's interest to upset the the apple cart, or the contract, it was assumed that the contractual arrangements between the parties were perfectly adequate to give you the necessary legal underpinning, which was said to be necessary. Now, my argument then with what has happened with the bill is not what it tries to do, but about how it does it. I do have, this may be unfashionable at the moment as a view to put forward, but I do happen to think that the Act could have been much, much simpler. In fact, I think, I've never been given an adequate answer as to why the powers of the Secretary of State back in 1992 were never exercised. There was no time limit on those powers. They can be exercised tomorrow morning if there were enough pressure so to do. That's another way of doing the same thing. You simply apply COGSA 92 to electronic bills of lading. My concern with the current bill, when it becomes an act, and it is clear that it will become an act, is that the bill goes beyond simply stating the principle of functional equivalence, but introduces the concept of reliability. For an electronic transport document to pass muster, as it were, under the new Act, it needs to be reliable. And there is a long list, a long litany of criteria which judges and arbitrators are going to need to make sure is satisfied. If you look at section 2, section 2 and 2.5, you have there a long litany of reliability criteria. I'm not going to go through them. But the question which arises in my mind is this. First, does the fact that we're in court about a misdelivery claim prove that this system was not reliable? Because let's face it, most cases which arise in the context of did you give the goods to the right party are going to arise in misdelivery claims. If you take the MSC case, that was precisely what happened. The guys who turned up for the valuable containers were not the guys who were entitled under the PIN number, to the PIN number. So are we going to face arguments about, well, we know it's unreliable because we're in court. Had there not been a failure in the system, there wouldn't have been a claim. Point number one. Point number two. How is a court, how is a judge going to decide matters of reliability? How do you do it? Are we going to go through taking expert evidence on the reliability of the system in order to establish whether we get into the Electronic Trade Documents Act at all? Because the Act is said to apply only to systems which are reliable. Therefore, A, how do you establish that it's reliable? B, what if you don't? Well, what if you don't? What do you do? What does that transaction, what happens to that transaction? Does it fall into COGSA 92? Well, it doesn't, because by deleting the sections which might apply the Act to electronic bills of lading, you can't apply COGSA 92. And if that happens, what happens to that transaction? Do the documents there become invalid, null, or do you simply apply the common law? And that gets you into all sorts of difficulties with possession, constructive possession, and possession of intangibles. Let me just give you one example of reliability of the criteria. If you go to the bill, and if you go to section 2 for F and G, the last two of the criteria, it refers to 5 F and G. Any assessment of the reliability of the system made by a body with supervisory or regulatory functions, or the provisions of any voluntary scheme or industry standard that apply in relation to the system. Now, the IG the international group of P&I clubs have a list of acceptable platforms. That list is made up of 3 at the moment. So the question which will arise is, what if you're not on that list? Do you, by dint of not being on that list, fall outside reliability? Query, what happens then? And you can flip that question around. What if you are on the list? Is it open to council still to challenge the reliability of the system? Because we don't know whether this list of criteria is conjuncted or disjuncted. Are you okay if you get through one or more of them, or do you have to get through all of them? Now, this may be good news for lawyers. In other words, I'm sure, I have no doubt, that there will be disputes once the bill becomes an act about we're always told the devil is in the detail, and this detail will be picked over. That's what lawyers do. They pick over the detail of a statute, and there is a hell of a lot of detail here which can be picked over, which to my mind is a shame, because the same laudable objective could have been obtained so much more simply by having Section 3.2, the principle of functional equivalence, stated boldly and exclusively in the new Act, or indeed achieving the same thing by applying Cox 92 to electronic bills of lading. And I think I'm told by my arbitrator that I've overstayed my welcome. Thank you.
Thank you very much. Yes, Matthew, thank you.
Thank you. Thank you very much. And may I just start by thanking the LSLC for inviting me to be part of this session today. Very privileged to be amongst such esteemed panelists. I want to start with myself, and both inside and outside of work. I am really passionate about technology, and I embrace it where I can, and that extends to digitalisation. So my home is a smart home, and I think I've printed no more than 5 documents since the pandemic. And I had a smile earlier this week when we agreed to print out the bill for a talk about electronic documents. So I love tech and I embrace it, but I work in an industry which is probably one of the most antiquated when it comes to customs and documentary practices. So you might expect me to be all in favour of the bill, and I am to a large extent, but I question its real impact. And I think here is where I'm going to disappoint Richard, who hopes that this is the start of changes. I've been talking about technology and disruptors in the maritime sector for a number of years now. And in preparing for this talk, I went back to a talk I presented in Singapore in 2017, when I ended with what I like to call my Martin Luther King speech of having a dream that at some point in the near future we would have paperless trade documents and a fully connected international trade ecosystem. That was the dream. Is the bill going to be a part catalyst of this? I'm not sure. I'm not convinced that it is. I'm going to give you my views on the bill, the positives, the negatives, and whether I think it will be a driver of change. And yes, there are going to be legal issues in relation to the bill, but I think that's an inevitable consequence of any new statute, of course, and particularly one which touches on centuries of English law and areas of English law, as the Law Commission made the point in their report, that are very complex and often where there is no clear, easy answer, or indeed in many cases logic. And then looking at the bill, and notwithstanding the legal nature of this seminar, my view is that it should be judged only part on its legal impact and its legal success, but also on the likelihood of success against its intended outcomes and as a platform for change. And I think this is where we have to benchmark the bill, and we have to do it against 3 things. The first of those, for sure, absolutely is the law. The second is the intended benefits of the bill. And then thirdly, I think, through a real-world supply chain. So let's start with the positives, and there are many. First positive, in my view, and regardless of what I say in the following, I think it's fantastic that we have this bill, full stop. trade and law are huge revenue drivers for UK PLC, and globalization presents a challenge and a threat to that revenue. So it's absolutely right that our legal system keeps pace or preferably leads the pack with development in international trade law. So there is, in my view, an element of this bill being needed from a perspective of selling UK PLC and remaining relevant, even if it doesn't create or lead to the dramatic or immediate change in the way that trade documents are used. And indeed, some of the countries that already recognise electronic trade documents as having the same effects as paper trade documents are major trading nations, US and South Korea. But also, there's jurisdictions who are regularly touted as providing real competition to the English legal system. So Singapore and the Abu Dhabi global market. Francis and I has a big practice in the Middle East. That's fantastic, but that's money I'd rather see coming into England. So I think the bill there is very important, that it at least sets the scene that we are being progressive and open-minded and trying to lead the pack. Secondly, second positive, in my view, I think the bill takes a very sensible approach. I like the way it has rejected the idea of an exhaustive list of documents, which was in the running at some point, and the way that the Law Commission has, I think, steadfastly at times avoided being overly prescriptive in its approach to legal concept and choosing instead to rely on or allow existing common law to shape or determine the key issues going forwards. And I think that's a fantastic thing, because one of the things I love about English law is that generally the decisions are the ones which you would expect. They're the right decisions, and they make common sense. And I think allowing the courts to continue to apply existing common laws to the issues will continue with that. And then the third positive, and this will come out of what I say next, and in some cases conflict with it, is that it does give a platform for future developments and others coming into the industry, and potentially it removes barrier to entry. And I think that's the biggest plus that I see, even if, in my view, that's probably not going to be immediate. So moving then to the negatives, having talked about the positives, I think I just summarised the positives as it's a progressive and sensible framework for the future. What are the negatives? Well, there's some negatives already expressed, perhaps a missed opportunity for doing something even more simply, and negatives I hadn't thought of in terms of how we are going to start determining, even if this bill applies once we're in a dispute. But as I said, for me, this is just one of the benchmarks of success, the legal aspect. So the big negative for me is probably the element of so what, or perhaps better phrases, so what next, and how will the bill be a success? How are we going to look back in 10 years and say it's a success? Well, the Law Commission's identified a number of factors relevant to the case for reform, including, as the Law Commission put it, and I'm not sure I agree, the significant shortcomings with existing platforms, and then the increased productivity, efficiency, and transparency, and the reduced costs through moving to paperless trade, removing some of the 50 documents the Law Commission says is relating to a typical drip bill of lading transaction. But for me, I wonder really how much the bill is going to impact on all of these points. So I start with the challenges of the existing platforms identified by the Law Commission, which were in essence that they rely on untested contractual workarounds, which increase the complexity of transactions. And that's a point that I'm not sure I agree on. The existing contractual frameworks created by those platforms may well have been complex to create and structure initially, but I think once up and running, I don't see how they add to the value, how they add to the complexity of transactions. I mean, simply put, they wouldn't have any users if they were more complex than paper trade. So I don't agree with the Law Commission there. Yes, they may well be untested, or if they are tested, then we don't get to hear about them because they are dealt with by private arbitration. But there's a risk of that with anything that comes out of the new bill as well. Of course, it is all going to be untested. And then looking at those existing platforms, probably the biggest downside for me is that they are effectively closed loop or private, so you have to be signed up to them members. But the same is going to apply of any new system that is going to operate pursuant to the bill. And Richard earlier mentioned the desire for traders having one nice platform. I don't think that's going to happen either. At some point, there will be a number of new entrants coming in with new technology that can tick every box in Section 2 of the bill. And they may well whittle down, but it's not going to be a one platform, one solution, certainly for a while, and I would question ever. So that's the existing platforms. I don't think it's going to do what the Law Commission hopes it would there. And then I look at the cost and efficiency benefit, and I ask two things: one, will it be achieved? And two, is the bill really necessary to achieve that in the first place? And the answer to both of those, unfortunately, I view as a no. So looking at the number of documents which do typically accompany a bill of lading, how much does the bill allow those to be in electronic format when they otherwise wouldn't be? And I think it's just the bill of lading, really. The majority of other documents, and there are a lot, health certificates, origin certificates, packing lists, export documents, customs documents, to the extent that they're not already electronic, the bill is unlikely to speed them up becoming so. And there has to be an element here, I think, of the pace of cultural and economic change globally. As Richard touched on, some jurisdictions and roles and places will continue to put great weight on paper documents. So customs was the example given by Richard, and I had in my back pocket the example of Bangladesh, where you're not allowed for the bill of lading to leave a country until the manufacturer has been paid for currency control rules. So that means really the bill of lading, the way that Bangladesh goods get paid for, have to be in an electronic format. And in other places, the IT infrastructure may just not be there for e-bills to work. And don't forget, a lot of the places where goods are manufactured or raw materials are extracted from the earth tend not to be very rich places with good IT connection and money to spend on computer hardware and software. The Law Commission also gives the example of cargo insurance and the way in which these are assigned from, in the case of CISLs, the procuring buyer to, the procuring seller to the buyer as potentially benefiting from this bill. Indeed, it mentions it a few times. But here's a solution that I don't think the bill is needed to fix it. In fact, I think it's been fixed a long time ago, which is simply cargo policies have a very wide definition of insured persons and cover buyers of goods. So in that sense, and although, as I say, it's mentioned a few times by the Law Commission, there is no real immediate need for the bill in the context of cargo insurance. And then this is really a theme that I continue with my question on the bill, the theme of immediate need for the bill to solve existing problems. I think that there just have been solutions to existing problems. We've talked about existing platforms and service providers. So that's in relation to bills of lading. But there are a number of other platforms where digitalisation in trade is already light years ahead. So examples of Covantis, which is a blockchain agri-commodity platform supported by the likes of ADM, Cargill and Bunge. They already have the solutions and benefits that are put forward by the Law Commission in making paperless trade. There's a huge amount of other examples as well. InsurTech initiatives which do away with the need for paper documents and achieve some of the Law Commission's benefits. And I was talking to a client last night who's at a large container line MVOC. Of the bills of lading they issue, only 7% of them are actually in hard copy formats. And the majority of what they issue is just express release bills or seaway bills. So I question if there is a need for the bill. I think the answer has to be yes, but whether there's an immediate need and whether it's going to lead to change. I think a lot of traders simply move to digitalisation without the bill, and I think there's much bigger wins in digitalisation in international trade that have either already happened or will happen independently the bill. So the bigger wins, I think, coming from big data, which Richard mentioned earlier, that's going to do far more for cost efficiency, productivity, and transparency in the supply chain than I think the bill will do. So look, there's an awful lot of other solutions out there that, as I say, work independently and without the bill. Some of them have been successful, some have stalled or failed, and an audience member has pointed out that TradeLens has in fact already been removed by Maersk, but I'm not sure we're seeing the end of TradeLens entirely. So does or would the bill have helped those that have stalled or failed? I think possibly, but maybe not. So I think really, in my view, the big advantage of the bill is to allow for a continued development of existing solutions and for e-documents to have traditional functions. But I just don't think we're going to see a huge change, I'm afraid. Wholesale and global change to existing customs and practices will come out of necessity. And I don't think there's really a necessity at the moment for all paper documents to move to e-documents, or it's going to come out of something we don't see at the moment. So third-party disruptors coming in with an Uber-type solution with a product where it simply doesn't make sense, or it is uncompetitive not to use it. And I'm afraid I just don't see that as existing yet, or being triggered by the bill when it comes into force.
Well, thank you very much, Matthew. I have two, not questions so much as messages from on my system. One is, I think, as Matthew said, TradeLens apparently has been discontinued, at least by, is it Maersk, I think. And secondly, I've been told that there are 10 platforms on the P&I list, apparently, now. Thank you. Sorry, thank you very much. I thought it was someone online, but anyway, thank you. Did anyone have a question then? Questions?
Hello. Yes, many electronic bills of lading have been in use for at least the last 15 years in certain trades and between certain big commodity houses, commodity traders. Problem arises with the small traders or the small merchant who hasn't got the facilities. So you have a chain and suddenly someone gets into it to buy something but can't pass it on. So it interrupts the chain. And one other issue is with the various customs clearances. You find in several countries, a lot of African ports and so on, the customs want paper documents for the tax, for customs clearance and so on. How will they be accessing to receive actually the electronic documents? Because basically you'll need a PIN that the seller of the cargo will apply to the documents, and you sell the PIN as you go along. But then when it comes to customs, if the customs receive it and then they deliver to the wrong person, and sometimes it does, then they deliver to wrong people, will the platform pay the cost of replacing the cargo?
Thank you. I have a related question, but let's see. Charles?
Thank you very much indeed for that contribution. These are very valid practical points. They're valid practical points which, it seems to me, go to the technology as opposed to the bill. And in other words, the validity of those practical points do not attack, it seems to me, the need for a statutory underpinning, statutory concept, if you like, of electronic bills of lading within the law. As has been said, even if we have that underpinning, the Act, as it will become, no doubt, that does not solve your sort of problem. And the problem of the big player, the small player, the person in the middle of a string, the person where there is no string, the Western European trader based in Geneva, and the other trader based in the Southern Hemisphere without the same experience. Now, those are arguments about the system. I do not minimize them in any way, shape, or form. But if those are not arguments against the bill, I think they are questions about how the system will work, which are perfectly valid. The traditional answer given is don't worry, because both the contracts and the rule books currently in use and the bill allow for the system to be interoperable between paper and documents. So if you went down a string and suddenly there was someone who was outside the string, we're told, don't worry, you can simply transfer into a bill of lading. And then when he sells or she sells to someone who is in the system, then it can be re-electrified. Well, yes and no. How practical is all of that? But again, I think I wouldn't want to be misrepresented to have said that the bill is a bad idea. The bill is not a bad idea. I completely agree that it is important for UK PLC, for English law, to send out the right message. We belong to the 21st century. We're not paper bound. My main argument is that could have been done far more simply without additional overlays of reliability, etc. Sorry.
No, thank you. I'm wondering, Richard, because you're the user, what do you say to that? Or do you want to add anything?
Yeah, I mean, just a couple of things. I mean, first of all, as I've said before, I'm not coming at this from a legal point of view, and I look at this from the trade point of view, and I think that basically we need the law to support the trade itself and to make the trade work well. We also need to change a little bit of an idea of what a document is, and the idea of this is a document that's going through an electronic process is actually something that we're just going to have to get our head around. It's not going to be a PDF that's going through an electronic process. It's not going to be passing a PIN number from party to party. It's going to be a question of actually properly identifying parties within a system, and I think this is something that's going to be very, very important, difficult to get our heads around because we're so used to doing trade the way that we have been doing it in the past. Now, I think that the comments that, you know, we're not there, it's not going to make a sea change. Most of my comments are really hoping that it will. And I've been hoping for a number of different reasons for the last 20 years that we're going to suddenly change and transform into electronic bills of lading. And maybe we will within 6 months, or maybe it'll take another 20 or 30 years, which I think will be a failure. I do think that it gives an opportunity. We'll talk about, you know, less developed countries. I think it gives an opportunity for them to leapfrog ahead of where we stand. And I think that's something that's very, very, very beneficial. I think we're going to be able to need to materialize documents. And so this is something that's going to be built into the system. They're going to have to make this work. Because there will be opportunities or situations where we need to have a paper document. But this is just for the system to actually allow it to happen. I think that where we stand at the moment, the systems we have in place are in my view, not sufficient, because that explains why we have about 1% of trade is handled by electronic bills of lading. Everybody I speak to within trading companies, within trade finance banks, shippers, receivers, everybody wants electronic bills of lading. Everybody wants to move away from these paper documents. And I spend way too much of my life printing bills of lading for an exchange of bills of lading in Geneva. And the other day I was on a call and I was printing out 72 pieces of paper for 12 sets of bills of lading. And it's just, what century are we in? And so I think that it's up to us to really find the answers to all of these questions that we have. And I mean, things are moving forward very, very, very quickly. TradeLens has been shut down by Maersk because Maersk ran it. Maersk was TradeLens. Maersk and IBM were basically all that TradeLens was. The problem was that you had one major carrier who was expecting the other carriers to use their system. The other carrier said, I'm not going to share my information with you. And so it didn't get taken up. But this is kind of teething problems for me. And I think that we do have an opportunity to move forward.
But what's the answer to the question?
The question of how do we have a paper document?
No.
Or how do we avoid pins getting moved from one point to the other?
How is it going to work? How is it going to work? I mean, I think that's, hold on a second. And I'd like to start off, the way the bill works, as I understand it, and I may be wrong, is that there is in effect a presumption that an electronic bill of lading, say, will be equivalent to a paper document. There's a presumption of that. And then under section, I think, 5, you can, I'm not sure, agree, or if there's a reasonable inference otherwise, then that presumption is displaced. So if you're a seller, a CIF seller, say, and let's assume just English law at the moment and forget about customs just for a moment in some foreign parts, the presumption will be that electronic documents will be sufficient. So as between the seller and the buyer, the seller will be able, as I read it, simply not to present a physical bill, but to do it electronically. I think, I may be wrong. The question then is, what about the buyer who hasn't really thought about this? Maybe should have thought about it. Suddenly says, oh no, I don't want that. So there may be some disputes about that. But under English law, I think that will be the position. That's the position in the sale contract. But to make absolutely sure, that CIF seller will have to make sure, depends where he is in the sale line, either his own FOB seller to him, or if he's an FOB seller, the relationship between him and the ship owner, got to get an agreement from the ship owner to produce an electronic bill. And I think in answer to the question, how is it going to work? As I say, the bill is great, I think, but how is it going to work in practice? In practice, it seems to me, and it may be just what Richard is saying, that it isn't going to work in practice unless all people in the chain either agree or don't agree. And if one party agrees and the others don't, or if the exception works in the way that I see it, there is no exception, then some parties along the line will be caught by being presented with an electronic bill, where down the line, his or her buyer will want a paper bill. So I see the real practical problems. I don't know whether Matthew wants to talk about that. And I'm focusing on the question, how will it work in practice?
I think, so the practical point about someone down the line wanting a paper document, I think that's probably the easiest bit to solve, which is that the systems, the platforms have the ability at any stage in, let's call it the chain, to convert that electronic information into a paper document. So that I think is relatively easy. The how does it work? I think that's the main question. How is it going to work? That's the one I don't have an answer to, because I just see the problems that have been identified of the closed loop private systems and not everyone being plugged into it, and having loads of different systems and people having to join them.
The way that various people use it is that basically, at least the bill of lading is issued, there's only one person which can give instructions in each company. So they just send it off and it is signed by the person who has the authority. Then the shipper will send it on to its own buyer. So it will have to be the same shipper. The shipper, of course, knows who the buyer is. If that buyer wants to sell the cargo, instead of endorsing over, we'll send a message to both the shipper and the ship owner, the persons obviously designated, to say that I no longer have property in this cargo. This cargo's property has been passed to, and give details of who it's been passed to. And then that continues like that until the end. And then when they come to discharge, they very often will say deliver to. Whoever will actually take physical delivery will have to go with authority and with passport and so on to identify themselves that they're the person that have the authority, and then the cargo is released to them. Now, unfortunately, because of customs issues in certain countries, then very often a non-negotiable customs purposes only bill of lading is issued to give a physical bill to the customs. And it hasn't created any problems. It's a sort of standard procedure. Whether legally it will be upheld is another matter.
I just had a message from someone who said that the platforms have a default to produce the paper when required. So that may be an answer to it. Charles, did you want to add?
Yes, Bernard, you mentioned the sale contract. And of course, most sale contracts, particularly in commodities, but not exclusively in commodities, incorporate Incoterms. And Incoterms have had the principle of functional equivalence emblazoned across, I think it's Article 1, since the year 2000. And that article is effectively Section 3.2 of this bill, point number 1. So as between seller and buyer, where Incoterms at any rate are incorporated into the sale contract, then there is no problem as between seller and buyer. Buyer is precluded from insisting on a paper document if Incoterms have been incorporated into the sale contract. The second point, the main purpose of this bill, as I understand it, I sit, of course, available to be corrected. But as I understand the purpose of this bill, it was not to establish the principle of functional equivalence as between sellers and buyers, but in order to apply the principle of constructive possession, in effect, as between the buyer and the carrier, to provide rights of suit in the same way as Section 2.1 does in COGSA 92 to the holder of an electronic bill of lading. Now, my view, as I've said at least twice already before, is that that could have been done quite simply through Section 3.2 of the bill. I fear that there's been a certain amount of overthinking about the bill, which is likely either to create legal problems of construction on the basis of reliability or of the reliability sections, or going to underdeliver on its promise. That is to say, is this the great white knight coming in? Answer, well, did we need this great a white knight?
It seems to me that in addition to what you were saying about Section 3, there is an attempt in the bill. It's sort of saying that paper and electronic are equivalent. And it's a kind of reassurance to people, not that they can proceed and you can turn one into the other, etc. What I'm hearing in this observation is that, subject to your point about the bill being briefer, everyone's saying this is probably a necessary step forward. It will help facilitate things. But the bigger issues, and Richard, sorry, I missed your talk. You might have said something different, but certainly what I heard from Charles and Matthew is that, particularly from Matthew, is that the actual issue may be whether these electronic platforms are really suited and will be widely accepted. Your closed loop point, Matt, different platforms competing, and whether there will be a massive flight to the platforms. Richard, I hear you saying the big trading houses want it, but people have identified the fact that you may have people on different platforms. So what I'm hearing is the bill is a step forward, but is the whole electronic trading system going to be given a huge shot in the arm by it? Especially when, to me, my sort of slightly Luddite interpretation of electronic, sending a PDF copy of a bill is kind of semi-electronic, and you avoid Charles's manila envelope. I know, Richard, there's still paper there, but it's going instantaneously, and
it's not. Sorry, just very, very quickly on that point. I think that we need to clarify that we're not talking about sending a photocopy of a bill of lading by scan. This is not what electronic bills of lading are all about. And I think that we need to move away from that kind of concept at all. And that's why I said a minute ago, we need to redefine our concept of what a document is. If it's a question of just taking a photocopy of a bill of lading and sending it to someone by email, we haven't moved forward. We need to actually have something which is much more secure, much more reliable, much more solid than that. And I think that's what we're going to move towards. And I think we are going to see quite a few changes, actually. I think a number of companies are going to be moving into this area in the next couple of months. And I think we're actually going to be seeing a bit of a sea change. I'd love to have this conversation again in 6 months and see where we stand. I think it'd be fascinating, because one of us is going to be sorely either disappointed or vindicated.
So Bernard, if I may, just one observation, Richard. There's that deep-seated desire, I think, for something tangible, and maybe a sort of lurking fear. What if the whole system crashes? I suppose you'll say there's infinite backup and
No,
Yeah.
I've had bills of lading lost in DHL. I've had bills of lading with coffee spilt on them. I've had bills of lading where one bill of lading said
still tangible.
1,000 tons and two bills of lading said 10,000 tons. We live in a system where we rely on a document which is fundamentally crap, excuse me, and we complain that what we have is not perfect. What we're proposing is not perfect. I think we have to realize we're going to move towards there over time, but it's better than what we have.
Yeah, I think the bill is a great step in the right direction. It is important to give the right message that we have been pulled into the 21st century. But let's not pretend that the bill, when it becomes an act, will solve all of these problems. To expect the new act to do that would be to expect far too much of it. It simply states very, very clearly, and I think it should have stated very much more succinctly, that carriers are now no longer in a position to complain about the legal effect of an electronic bill of lading because it is electronic. That alibi has gone. That is a good thing. That is a good message to put out. What is, I think, what would be unfortunate is if the market believed that the enactment of this act was going to solve all of the other problems. But those other problems are not created by the law or by legal concepts. They are created by the technology, and technology, hopefully, will advance apace. Another question which has arisen is, will the Act make the rule books unnecessary? Will the Act make the contracts which surround all of the proprietary systems currently unnecessary? I don't think it will. I think the market will still try to explain the contractual situation between carriers and merchants and traders. Would that be a bad thing? Answer no. That happens in the paper document, in the paper world as well. Thank you.
Any more questions? Yes.
Hello.
Hello.
I had what's possibly a slightly basic question. I noticed from the presentation that even without the Act of Parliament proposed, e-bills seem to have been wildly successful, but only in container shipping. So lots of container lines use them, but they're not used very frequently in bulk trading. I've never seen one, and I deal with bulk trading disputes almost exclusively. So my question is, what makes bulk traders so much more wary of electronic bills, where they seem to have had significant uptake in container trade? And is this problem something which is addressed by the Act proposed?
Right. Matthew?
Oh, we're all whispering here. I think the first point, e-bills of lading not wildly successful in the container trade. But because I don't think they're needed in the container trade, because an awful loss of the container trade is trade between a buyer and a seller, where the seller knows the buyer. So the function of the bill of lading there would typically be so that the seller makes sure they get paid before they release the bill. When you're dealing with a buyer that you know either you're going to get paid because it's a big multinational, or you get paid and then you just simply put the bill to express release. So maybe you don't even have the bill of lading issued in the first place. It's issued in PDF. It's not an electronic document as the bill means, but it's never printed, and it's just express release. But the difference between the container and the bulk trade, I think, is just the number of parties in the bulk trade and the way that goods are traded. As I said, most container vessels, the end destination and the end user when the vessel leaves the port, but that's not the case in the bulk trade. So there's more problems there.
The very earliest genre of electronic bill of lading was the Seaway bill. Because with a Seaway bill, you don't need presentation. You therefore don't need transfer. Bob's your uncle. There you are. You have an electronic bill of lading. It's been around for years and years and years. So that is really why there is this concern about the legal underpinning of electronic bills of lading in the bulk trade because of strings. In the container trade, you don't have strings quite as regularly as you do in the bulk trades.
Yeah, yes. Mike coming.
Isn't it a question of the banks wanting bills of lading for the letters of credit?
Again, that is an issue which goes not to the bill, but to the system. There is a big question mark as to how do the banks react in the context of electronic bills of lading. The counter argument to that is banks are also wary and chary about how they appear on paper bills of lading. Banks do not want bills of lading to be endorsed to them. They want all the pluses, the benefits of security, without actually appearing as a party on the bill of lading. Why? Because they've learnt, some to their cost, that appearing as an endorsee on a bill of lading may bring with it bits of the bill of lading they did not want. That is to say, liabilities towards carriers. So again, that is not an argument against the bill. It is an argument, it is a question really about how does this Rubik's cube of international trade actually work? How do you preclude certain arguments as between consignee and carrier? How do you preclude certain arguments between buyer and seller? But above all, because it's where the money is, what about the banks? So
we haven't forgotten Richard. Richard, do you want to say anything about this? Or
I mean, I would say just very quickly on the container lines, and I do speak quite a bit to MSC in Geneva without speaking on their behalf in any way. The electronic bills of lading have not been wildly successful in container lines. I agree with my panelists. There is a massive push for that, actually. I think there was a pledge. In fact, I'm looking at the pledge now. There's a pledge for the liner companies to go 100% e-bill of lading by 2030. I would say the difference between liner and bulk or liner and conventional is the liner carriers have much more power. I think they have much more control over the documentation. We're talking about a much more concentrated market. And so we're not talking about hundreds of different carriers. We're talking about essentially 4 or 5 who control 70% of the market. And so I think it's a lot easier for them. The problem the liner trains have at the moment is if you look at all of the different big carriers, the big lines, they've all chosen their champion. And so, I mean, MSC is using Wave, Maersk was using TradeLens, CMA CGM was using another. None of them want to use the others. And so now we end up with essentially one system for each of the carriers, which to a certain extent locks their users into their system, into their ecosystem. And it kind of actually makes a lot of sense for their business. And that's, I think, why they're going to be pushing for it more, because they're trying to sell additional services to go with their container lines at the moment. They're trying to sell financing, insurance, things like that. And having people on their system without being able to leave is actually a very attractive proposition.
Thank you. We're going to have to stop shortly. One more question, please.
Yes, good evening. Thank you very much for making it all sound so simple. And as somebody that spent the early years of his life going through mates' receipts and bills of lading on board a ship, I would certainly welcome all of this. So at the beginning of the presentations, we heard that the UK is one of 3 countries that's produced a bill about electronic bills of lading. How many other countries need to do the same to enable the introduction of electronic bills of lading? Does it just need to be the law that's applicable on the bill of lading, or do we need to have it at the export and importing countries as well?
I think that's a battle that, well, firstly, there's no clear answer, and it's a battle that's never going to be won, in the same way that we still have battles on bills of lading. If I have a bill of lading issued in China that provides for English law, the Chinese courts are still going to take jurisdiction over that. So how many do we need? I think, well, none, but we just have to accept that it is not going to be a one-size-fits-all solution around the world. There are going to be problem areas for any number of different reasons, but as there already are in different ways.
Right, I think we're going to have to stop there. I have one major complaint with the bill, because it seems to me there is one glaring omission, and that is that the list of documents which should be capable of being equivalent in electronic form is, of course, an arbitration award. That appears to be omitted here. Here I am, I think yesterday, a signature page being sent to Singapore, then coming back to, I think, somewhere in Sussex, and then coming back to Chambers to be signed. But that's rather, I think, a flippant remark. But even in this day and age, the idea that arbitration awards have to be signed physically, I think actually is a matter of English law, and that isn't true. But I think as a matter of foreign law, and that's the problem. And that's why it relates to the point that the gentleman at the back made, and that is that ultimately, if you're looking to enforce an award and maybe even deal with a bill of lading, it doesn't really matter what English law is. You've got to look at the other country that may be involved in that. Anyway, I'd like to say a number of things. One is, I'm afraid Francis had to disappear to something else, and he did apologize, and I should convey that apology to you all. I'd like to express my thanks to the panelists. Thank you. I'd also like to express my thanks to 36 Stone for the drinks, food before, for the drinks and food after. Do stay on if you like, and chat with our panelists, I think. Anyway, thank you very, very much.